In May 2007, 113 out of 121 MPs in the New Zealand Parliament voted to criminalise all parents who correct their kids. They did this by repealing Section 59 of the Crimes Act and replacing it with a new Section 59 which criminalised parental correction, and despite polls consistently showing 70 to 80% of New Zealanders were opposed to such a law change. 22 months later, another poll showed Kiwis still overwhelmingly opposed to the law change, to the tune of 83%. It's been said most people don't understand the law, but if they did, they would find it's not as bad as they think. I say it's far worse than most imagine. The trouble is most people haven't read it for themselves, and that apparently includes many journalists, media front people, and perhaps even members of Parliament. The old law was a masterpiece of simplicity, brevity and clarity, and best of all, presumed parental authority was valid. It said, "Every parent of a child is justified in using force by way of correction towards the child if the force used is reasonable in the circumstances." There was only one ground specified for using force toward a child, and that was for correction. Further, by defining the force used as reasonable in the circumstances, all force unreasonable in the circumstances was unjustified and thus illegal by definition. By contrast, the new law is wordy, confusing, and much of it redundant. One thing, however, is crystal clear. Correction, which was the only specified ground for reasonable force to be used toward a child, is now the only ground explicitly ruled out as illegal and unjustified. The new law says, "Every parent of a child is justified in using force if the force used is reasonable in the circumstances and is for the purpose of preventing or minimising harm to the child or another person, or preventing the child from engaging or continuing to engage in conduct that amounts to a criminal offence, or preventing the child from engaging or continuing to engage in offensive or disruptive behaviour, or performing the normal daily tasks that are incidental to good care and parenting. Nothing in subsection 1 or in any rule of common law justifies the use of force for the purpose of correction. Subsection 2 prevails over subsection 1. To avoid doubt, it is affirmed that police have the discretion not to prosecute complaints against parents of any child, or those standing in the place of any child, in relation to an offence involving the use of force against a child, where the offence is considered to be so inconsequential that there's no public interest in pursuing a prosecution. First, the new Section 59 is mislabelled when it's called the anti-smacking law, since smacking is not mentioned anywhere in the law. It's actually the anti-correction law. Second, the term force is not defined in either the old or the new Section 59. However, the definition of assault from Section 2 of the Crimes Act applies to Section 59. Assault means the act of intentionally applying or attempting to apply force to the person of another, directly or indirectly, or threatening by any act or gesture to apply such force to the person of another, if the person making the threat has, or causes the other to believe on reasonable grounds that he has, present ability to effect his purpose. Force is not defined as physical only, but includes threats and gestures, which of course do not involve physical contact. Thus labelling the new law the anti-smacking law and equating force with smacking misleads because it conceals the fact that all force, physical and non-physical, which is intentionally applied to the person of another, is made illegal by this law, unless an exception is made. The old Section 59 included one exception. The new Section 59 includes 4. Let's be clear. Force is always used to correct a child, even if it's only the force of the parent's will over that of the child, and communicated to the child by words or gestures in some way. Thus, because no force as defined by the Crimes Act is now allowed for the purpose of correcting children, all such correction now falls under the definition of assault and is thus illegal. Third, it was claimed repeatedly that the term reasonable force in the old law allowed parents to abuse their kids. 4 things. Abuse is unreasonable force and was always illegal according to the old Section 59. Virtually all the old law, including reasonable force, is in the new law. So if reasonable force gave grounds for abuse under the old law, it does precisely the same for the new law. In the old law, there was only one ground justifying reasonable force: correction. In the new law, there are 4 grounds. Clearly then, the new law has increased by 4 times the grounds under which abuse may occur. If abuse really was the reason behind the law change, and if abuse really did occur because reasonable force was in the old law, why was reasonable force included in the new law and its role expanded? If it's such a horrible concept and such a great shield for abusers to hide behind, surely it should have been removed. It wasn't. Sue Bradford said on national radio 21st December 2007, that is 7 months after her bill became law, "The epidemic of child abuse and child violence in this country continues. My bill was never intended to solve this problem." With this statement, Bradford revealed that despite her long campaign to repeal Section 59 so as to stop child abuse, that wasn't her real reason for changing the law at all, and there was some other reason for changing it. What was that reason? She has never told us, and neither have Helen Clark, John Key, and all the other proponents of the law. Fourth, the only thing of real significance that changed between the old and the new law is that correction, which was authorised and commended in the old law, was made illegal in the new law. Nothing in subsection 1, that is, the 4 exceptions, or in any rule of common law justifies the use of force for the purpose of correction. Subsection 3 makes this emphatic. Subsection 2 prevails over subsection 1. That is, the criminalisation of correction overrides everything else. Thus we now have the absurd situation where parents can use reasonable force to stop a child running onto a road, but not to correct them so they don't do it again. Fifth, subsection 4 is known as the Key Amendment after John Key. Twice in this section, force used for the purpose of correction is referred to as an offence. This reiterates that such force is now a criminal activity by definition, whether or not the person correcting the child is arrested and charged, or whether the offence is known about and reported. A thief is a criminal, whether or not they are caught and charged. Parents who correct their children are also now criminals, whether or not they're caught and charged. If parents believe it's their duty to correct their children, they now have to be willing to break the law. Correction of children is now a risky, illegal activity to be hidden from view, like stealing. In subsection 1D, it says that reasonable force can be used for performing the normal daily tasks that are incidental to good care and parenting. Incidental means secondary, of less importance, of minor consequence, occurring merely by chance or without intentional calculation. Subsection 4 says in part, it is affirmed that police have the discretion not to prosecute where the offence is considered to be so inconsequential that there is no public interest in pursuing a prosecution. Inconsequential means of no importance or significance, of no consequence. I would argue correction is not incidental but central to good parenting. However, Parliament didn't even rate it as highly as incidental, as they excluded it from things incidental to good parenting. Nor is it inconsequential. Correction is not a matter of lesser importance but of greater importance. It's not a matter of minor consequence but of major consequence. Correction is not secondary but primary. It's not inconsequential but important, of significance, and produces a consequence, a change in behaviour. Thus, the new law says that parents can do what is less important to parenting but not what is more important. That parents may control their children's behaviour at any time, but if the child's behaviour is corrected, then you may be charged. Parliament in effect said, if you're a bad parent and don't correct your kids, you'll be okay. But if you're a good parent and do correct your kids, we'll criminalise you. Go to familyfirst.org.nz and read for yourself some horror stories, any of which could easily be your story. What should the government do? It should repeal the new Section 59 and should reinstate the previous law as it was clear, brief and comprehensive and accepted parental authority as valid. But there's something you can do. In August, a postal referendum will be held so all New Zealanders can have their say on this matter. Vote no to the referendum question. Should a smack as part of good parental correction be a criminal offence in New Zealand? Vote no in the referendum.